Reagan. Previously, Mr. Iyer clerked for Justice William Rehnquist and Judge Malcolm Wilkie of the D.C. Circuit. After his career in public service, he was in private practice and has also taught extensively at law schools around the country. Mr. Iyer received his B.A. from Stanford University and his M.A. and J.D. from Harvard University. Aaron Zielinski is an assistant U.S. attorney for the District of Maryland. Previously, Mr. Zielinski served as a special assistant United States attorney in the District of Columbia, as an assistant special counsel in Special Counsel Robert Mueller's office, and a special assistant to the legal advisor in the State Department. Previously, Mr. Zielinski clerked for Justice Kennedy before his retirement from the Supreme Court, and for Justice John Paul Stevens after his retirement, as well as for Judge Thomas Griffith on the D.C. Circuit. Mr. Zielinski received his J.D. and B.A. from Yale University. I note for the record that pursuant to Section 4C6 of House Resolution 965, Mr. Zielinski's personal counsel is participating in this hearing on the WebEx software platform. John Elias is a trial attorney in the Antitrust Division of the Department of Justice. Since joining the department in 2006, he has served in a variety of roles, including acting chief of staff of the Antitrust Division. In 2015, following a detail to the White House's Presidential Personnel Office, he joined the Office of the Associate Attorney General, where he served for various periods as counsel, chief of staff, and deputy associate attorney general. Mr. Elias received his J.D. from Stanford Law School and his B.A. from Yale University. The Honorable Michael Mukasey served as the United States Attorney General from November 2007 to January 2009 under President George W. Bush. Prior to his service as Attorney General, he served as a judge in the Southern District of New York, becoming Chief Judge in 2000. Previously, he served as an Assistant United States Attorney for the Southern District of New York. He is currently in private practice. Judge Mukasey received his law degree from Yale University and his B.A. from Columbia College. We welcome all of our distinguished witnesses, and we thank them for their participation. Now, if you would please rise, I will begin by swearing you in. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show the witnesses answered in the affirmative. Thank you, and please be seated. And let me extend a special welcome to Judge Mukasey, whom I well remember from our...
Mr. Chairman, could we get a vocal from Mr. Zielinski? All we could see was his hand up.
Well remember from our dinners at...
I guess not.
At Ramaz. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, for those witnesses testifying in person, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For Mr. Zielinski, there is a timer on your screen to help you keep track of time. Mr. Iyer, you may begin. Yeah, your mic.
Good afternoon, Chairman Nadler, Ranking Member Jordan, and members of the committee. Thank you very much for inviting me to appear today. I was privileged to serve in the Department of Justice under 2 Republican and 1 Democratic president, and I am here because I believe that William Barr poses the greatest threat in my lifetime to our rule of law and to public trust in it. That is because he does not believe in its core principle, that no person is above the law. Instead, since taking office, he has worked to advance his lifelong conviction that the president should hold virtually autocratic powers. That includes immunity from nearly all checks and balances and being able to accord special treatment to himself and his friends. The system that Barr is working to tear down was put in place in the aftermath of the Watergate scandals, which involved extensive government corruption and caused a widespread loss of trust. After Nixon resigned, President Ford's Attorney General Edward Levy acted swiftly to restore trust by supporting reforms to prevent such abuses. These included statutes like FISA, the First Inspector General Act, expansion of FOIA, and the Whistleblower Protection Act. Levy knew that public trust ultimately depended on people believing that ours is a government of laws and not men, in which no person is above the law. That had special significance for the Department of Justice, whose work he saw imbued with a judicial nature. Its awesome powers demanded transparent and orderly decision-making processes subject to review at multiple levels and free from improper personal considerations or political interference. Levy emphasized the critical role of a dedicated professional staff who would bring zeal and determination and a great concern for fairness and impartiality. This vision has been an inspiration to generations of department lawyers. Bill Barr's service since last February has been a root and branch attack on Edward Levy's vision and reforms, indeed on the very idea that no person is above the law. Barr has sought to give the President nearly unlimited powers by negating or overriding many independent processes that operate as important checks on executive branch action. Here are some of the things that he has done. He has worked to defeat any meaningful oversight, either by Congress or by review in the courts, through litigation, legal opinions, and his own speeches. He has himself refused multiple times to show up in response to requests to appear before Congress. He has worked to undermine Congress's appropriation power by litigating the President's right to divert funds to pay for his border wall, which Congress refused repeatedly to fund. He has regularly undermined the authority of independent decision-making processes and career professionals whose disinterested integrity Levy saw as a key element justifying public trust. He has done this by his own statements, such as last March when he publicly whitewashed the Mueller report's extensive findings on obstruction of justice, and last December when he publicly contradicted key conclusions reached by Inspector General Horowitz in his FBI election interference probe. Both times, Barr's intervention vocally reaffirmed positions advanced regularly in presidential tweets. He has also done it by enlisting various political cronies to review and reverse decisions of experienced career attorneys, or by simply replacing them in handling matters of personal interest to the President. This is how he accomplished the reversals of long-held department positions in the cases of Trump associates Roger Stone and Michael Flynn, urging a much lighter sentence in one case and outright dismissal in the other. In a number of other matters, such as the intake of information from Rudy Giuliani and investigation of unmasking requests during the Obama administration, Barr has set aside certain subject matter to be handled by people in his political inner circle rather than by career officials who would deal with them in ordinary course. Finally, Barr has willingly supported removal of officials when their attention to duty proves politically inconvenient to the President. The treatment of U.S. Attorneys Jesse Liu here in the District of Columbia and of Jeffrey Berman in New York last Friday are two blatant examples. So is his standing by and voicing support as Trump, during April and May of this year, has removed 5 inspectors general who have long served as an important check on executive branch corruption. To an ever greater and quite shocking extent this spring, Barr has used the great powers of the Department of Justice to advance the President's narrow political interests and gravely undermine constitutional rights and the functioning of our democracy. Consider his apparent role in overseeing law enforcement action on June 1 to deny the right of peaceful protest in Lafayette Park, or the plainly frivolous motion filed last Friday to deny and denied one day later to enjoin publication of John Bolton's book for disclosing facts embarrassing to the President. Or worst of all, I think, are his flamboyant media discussions of the facts supposedly unearthed by the specially commissioned investigation he is personally conducting with the help of U.S. Attorney John Durham. Repeatedly, Barr has echoed the President's tweets and conclusively characterized the FBI investigation of Russian interference as an effort to spy on the Trump campaign and, as he put it, one of the greatest travesties in American history. And he has hinted repeatedly that indictments are likely. This conduct is a textbook violation of Justice Manual Rule 1-7.400, which bars public comment on criminal investigations before charges are filed. Here, though, the wrong is much worse, as Barr is using a criminal investigation to produce fodder for the President's campaign propaganda mill, which can have its effect even though it is false. This conduct in particular gives cause for great concern about what Barr may do next. Just another 30 seconds. In closing, it needs to be said that Bill Barr does regularly lie in ways that impact official action. Along with his continuing media project to make Americans believe that the FBI conspired against Donald Trump, his statements about the Mueller report, Jeffrey Berman's supposed resignation, and Barr's own role in the events in Lafayette Park come quickly to mind. So does his practice of regularly shrouding himself in the rhetoric and trappings of the rule of law, even as he desecrates and undermines the institutions that make it possible. But to me, Barr's crowning dishonesty
Gentleman's
is
time
the
has
portrait
expired.
of Edward Levy that a recent New York Times article showed hanging on the wall of his conference room, as though the current incumbent has
Regular
anything.
order, regular order, the witness will conclude.
We're way beyond regular order.
The witness will continue.
Can I have one more sentence, Your
By
Honor?
all means.
Okay. But to me, Barr's crowning dishonesty is the portrait of Edward Levy that a
Mr.
recent
Chairman, I would
New York
ask that
Times-
that the sergeant at arms
The witness
be
will
called
conclude.
upon to stop the disruption of this meeting. I can't hear this witness. This is a very important witness.
Yeah, well, he's way beyond
And the
his
chair
time.
has
And if
the
there are no
authority-
rules about
the
when
chair
people
has the
can talk,
authority, does
there's
he
no
not?
rules about when you can make noise.
The gentleman makes a
Doesn't the
good
chair-
point, and the chair will enforce the 5-minute rule. Witness will proceed. will
Chair is
continue.
not enforcing the
Will con-
5-minute
The
rule.
witness will conclude.
Mr. Chairman, this is outrageous. Do you have no respect for the rules whatsoever?
The witness will conclude.
He's 2 minutes beyond concluding, and you don't let us have that kind of time. You gavel down immediately. You're being grossly unfair. This man had a
witness will
written
conclude.
statement, and he knew to cut it to 5 minutes. He couldn't do it. Either we have rules or we don't.
The gentleman will suspend. The witness will conclude.
Thank you.
Well, then
In
we can keep
closing, it
making
needs to be
noise.
said that Bill Barr does regularly lie in ways that impact official action.
Mr. Chairman, there's not order in the room. There's a banging.
No,
that's
there's certainly not.
disrespectful.
Mr. Chairman, would you have Gene Krupa removed?
The witness will conclude.
That's what you said a while ago, and he didn't conclude.
The gentleman will suspend. The witness will conclude.
So I guess the last thing I want to sum up with, I've said all the rest of this, but the last point I'd like to make is that I think his crowning dishonesty in the face of what he is doing to the Justice Department is the picture that I saw in the New York Times a few weeks ago, a portrait of Edward Levy on the wall of his conference room, as though the current incumbent has anything but disdain for the beliefs and achievements of his predecessor. Thank you, Your Honor.
Thank you.
Mr. Chairman, I have a parliamentary inquiry.
Gentleman will state his parliamentary inquiry.
Is it not appropriate for the chair to exercise discretion in extending the 5-minute rule as the chair sees fit?
It certainly is appropriate.
And is it authorized under the rules of this committee?
It certainly is authorized under the rules of this committee.
Well, then, cannot the chair call in the sergeant at arms to maintain order when a member of this panel is out of order and disrupts the
We'll move
meeting?
on to the next witness.
Parliamentary inquiry, Mr. Chairman.
Mr. Elias.
Parliamentary inquiry, Mr. Chairman.
Mr. Elias.
Parliamentary inquiry, Mr. Chairman.
Mr. Elias.
Parliamentary point of order, Mr. Chairman.
There is no point of order.
How do you know I've not said one? Here we go
The
again.
gentleman is completely out of order, Mr.
The
Chairman.
gentleman will state his point of order.
Point of order is according to the House rules, a House chairman cannot capriciously determine the 5-minute rule at the whim of what he wants. It has to be fairly and impartially applied. That is the spirit of the House rules, and that is not what has happened.
You'll apply it fairly?
We are applying the 5-minute rule as provided by the House rules.
So you're ruling on my point of order?
The gentleman has not stated the point of order.
I did say the point of order. I stated the point of order is the rules are being violated by a capricious chairman who is not following the rules of the House by arbitrarily deciding when the 5-minute rule will be applied and when it will not be applied.
You have not stated a cognizable point of order. The chairman has discretion.
Mr. Chairman, you've not stated a recognizable way of running a committee in 18 months. So, I mean, let's determine it.
The gentleman will suspend. The gentleman has not stated a cognizable point of order. Mr. Elias.
I did earlier, and you blow over it.
The gentleman will suspend. Mr. Elias.
Good afternoon, Mr. Chairman, Ranking Member Jordan, and members of the committee. My name is John Elias, and I am a career attorney with the Department of Justice. I joined the department in 2006, and over the past 14 years, I have served under 6 attorneys general and 3 presidents. I've spent my entire legal career at the department. Although I am a current department attorney, my testimony is personal and does not represent the views of the department. Throughout my career in federal service, I have been taught to do the right thing for the right reasons in the right way. That is why, earlier this year, I asked the DOJ Inspector General to examine whether multiple antitrust investigations launched under Attorney General Barr were abuses of authority or other misconduct. The first matter that I referred to the IG concerned 10 investigations that the Antitrust Division launched into merger activity in the marijuana or cannabis industry. These mergers were not even close to meeting established criteria for these kinds of investigations. And yet, these cannabis investigations accounted for a full 29% of the division's full review investigations last fiscal year. For context, these kinds of investigations are rare. On average, only 1% to 2% of the thousands of transactions that come before the division each year get a full review. In the first of the cannabis investigations, the merger of MedMen and PharmaCann, career attorneys examined the proposed deal and determined that the transaction called for no further antitrust review. Staff reached this conclusion using the criteria under the horizontal merger guidelines that have guided the division for decades. However, on March 5th, 2019, Attorney General Barr called the Antitrust Division leadership to his office and ordered the division to proceed with a full investigation. The division staff complied, issuing burdensome 15-page subpoenas that compelled production of 1.3 million documents from 40 personnel, all at great expense to the companies. Although the division ultimately found no evidence of antitrust problems, the companies abandoned the merger, citing delays in regulatory approval. The Antitrust Division went on to conduct similar investigations of 9 other mergers in the cannabis industry. Division staff continued to document at the outset the lack of any bona fide antitrust issues. In some cases, the companies operated in completely different geographies and did not compete at all. Nonetheless, the division continued to issue subpoenas and compel productions of millions of documents from these businesses. At one point, the office handling agriculture became so overwhelmed with cannabis investigations that it had to pull in attorneys from the telecommunications, media, and technology offices. In response to staff concerns about these investigations, the head of the Antitrust Division, Assistant Attorney General Del Rahim, acknowledged at an all-staff meeting that the cannabis industry is, quote, unpopular on the 5th floor, unquote, referring to AG Barr's offices at DOJ headquarters. But personal dislike of an industry is not a valid basis upon which to ground an antitrust investigation. The next investigation that I reported to the IG concerns an arrangement announced in July 2019 between California and 4 automakers to limit fuel emissions. After news reports indicating that the president was enraged by the arrangement and wanted to retaliate, President Trump criticized the deal on Twitter. The day after the tweets, Antitrust Division political leadership instructed staff to initiate an investigation that very day. Ordinarily, decisions of import, here an investigation of a $630 billion automobile market, would take time and care to evaluate, especially when the action would face defenses. In the hurried investigation paperwork, staff acknowledged that it had only partially examined public information. Members of the committee, I have undertaken whistleblower activity and am here today because I recognize the imperative for law enforcers to operate even-handedly and in good faith. I reported these matters to the IG because they were evidence that our nation's antitrust laws were being misused. These laws have protected American markets and consumers for more than a century. The hundreds of career staff at the Antitrust Division take this mission seriously and expect DOJ's political leadership to as well. I thank you for examining these issues and will be happy to answer your questions.
Thank you. Attorney General Mukasey.
Thank you. Good afternoon, Chairman Nadler, Ranking Member Jordan, and members of this committee. Thank you for inviting me to testify at this hearing. The topic of today's hearing, claims of politicization of the Justice Department, is serious and important because the fundamental duty of the department is to pursue equal justice under the law, and we can and should expect no less. As you may know, I was privileged to lead the men and women of the Justice Department during the George W. Bush administration. Before that, I served as a for over 19 years as a district judge in the Southern District of New York, and that's the perspective that I bring to the testimony today. The department needs capable, experienced, and even-handed leadership. Its components and programs have reach across the country and across the world. It handles matters as diverse as antitrust and anti-terrorism. It takes an experienced lawyer and leader to manage such a department effectively, and I believe without reservation that William Barr is that kind of a leader, and that this country is fortunate that he leads one of the most important government departments. I do not have first-hand involvement in the particular matters to be discussed today, but based on my own experience, I can assure you that those are not issues of first impression for the department or for the federal courts. The Justice Department is not politicized because senior officials disagreed with the sentencing recommendation from Mr. Stone. Trial lawyers in the department are zealous advocates. That's their job. But zeal does not confer perfection or assure justice. My views on this case are no secret. I set them out in a piece written with Attorney General Meese in the Wall Street Journal, where we pointed out that the sentencing guidelines, which were adopted in 1987, initially as presumptively binding on the courts, have been strictly advisory since 2005 under Supreme Court law. Both as a judge and as Attorney General, I have declined to follow sentencing recommendations from trial lawyers. As Attorney General Meese and I wrote, prosecutors are supposed to seek justice, not to play the sentencing guidelines like some sort of pinball machine to see how many times they can ring the bell, or to try to pressure a judge to impose a harsh sentence, and also thereby cast doubt on the competence of the government by reading guidelines in a didactic and hyper-technical way without applying the one element that must be present when you read any law, whether statute or guidelines, and that is common sense. In a highly publicized and politically fraught case, it was not only proper but also advisable for the Attorney General to assure that the government's sentencing recommendations not promote that unworthy end. The decision to lower the recommendation was reached by others in the department as well, including career lawyers, one of whom signed the lower recommendation. Attorney General Barr said publicly that he believed Mr. Stone's prosecution was warranted, and that with his conviction that a jail sentence was warranted, and that the jail sentence imposed by the judge was appropriate. I believe the trial judge agreed with the initial sentence, that the initial sentencing recommendation was overly harsh, as her sentence reflects. The Justice Department is not politicized because prosecutors dropped charges against General Flynn. In fact, as you heard this morning, the D.C. Circuit issued a writ of mandamus directing that prosecution stop. As I understand it, the former FBI director talked publicly about having sent agents to interview General Flynn without following applicable protocols. And not using proper protocols wasn't simply a delicate problem of etiquette, like using the fish fork instead of the salad fork. It followed the deputy director's assurance to General Flynn that he need not have a lawyer present, and having agents base their investigation on a potential violation of a law, the Logan Act, that has never been prosecuted successfully since its adoption in the 18th century, is probably unconstitutional, and that no rational person would apply to a potential national security advisor in any event. And this morning we saw documents showing that that theory was discussed on January 4, 2017 at a meeting in the Oval Office, which is to say the interview was a pretext for getting General Flynn, as one senior FBI official put it, to either lie or admit to something that could have him fired. The duty of the department is to do justice, and that does not end after a guilty plea, particularly when that plea is procured with a threat to prosecute the defendant's son, that is concealed from the court and the probation department so that it would not have to be disclosed to future defendants against whom General Flynn might testify. That is a particularly gag-inducing feature of this episode to me as a former district judge, that was being kept from the court. It is not unheard of for a prosecution to be dropped even after a guilty plea following the disclosure of new information that shows continued prosecution would be a miscarriage of justice. There seems to be a tendency these days to read ulterior motives into every action of Attorney General Barr. As Attorney General Meese and I noted in our article, it's helpful to consider a few data points from Attorney General Barr's tenure. First, despite his own skepticism about aspect of Special Counsel Robert Mueller's investigation, he allowed that investigation to run its course. Second, he supported the decision not to prosecute Former Deputy FBI Director Andrew McCabe, a frequent critic of the president, despite evidence that not only did McCabe lie when he denied leaking information, but that he also berated others for the leaks so as to deflect suspicion from himself. He also
Mr. Chairman, point of order. We are again being disturbed by tapping as the chair exercises his discretion in letting the witness testify beyond the 5-minute rule, and I'd like for that tapping to stop, and if it doesn't, I'd like for the
You want somebody removed because they want the rules enforced?
Order.
That's amazing.
Mr. Gomer, you're not presiding over this hearing. Mr. Nadler is.
The members will show
Some of us
courtesy
would
to
like the rules enforced.
The members will show courtesy to the witnesses, Mr. Gomer. The witness may proceed.
Thank you. So far as the claim that William Barr's service is somehow a desecration of Edward Levy's service, I should point out that Edward Levy's portrait hangs where it hung when I was Attorney General, and that Edward Levy's grandson serves proudly as Attorney General Barr's Chief of Staff. So that attack is totally unjustified. Now, I've come to know Attorney General Barr over the years. I've had many discussions with him about the law and about public policy issues. And based on that, I have no doubt that the welfare of this country, upheld through the even-handed application of law so as to achieve justice, is what motivates him and motivates his decisions, and that's all that motivates his decisions. I think we're fortunate to have a person of his temperament, talents, and convictions in office during this difficult time in history, and I thank you very much, and thank you for your indulgence, Mr. Chairman.
Thank you. We'll now proceed under the 5-minute rule with questions. Before I recognize myself... Oh, didn't we? Nope. He's on. He's testifying. Oh, I am sorry. We have Mr. Zielinski on video, and I didn't realize. Mr. Zielinski will now testify.
Good afternoon, Chairman Nadler, Ranking Member Jordan, and members of the committee. In response to your subpoena, I'm here today to testify about United States versus Roger Stone. I apologize for not appearing before you in person, and I thank the committee for allowing me to appear remotely today. For family reasons, I should not risk infection. As the chairman mentioned, I'm privileged to serve as an assistant United States attorney, a nonpartisan career prosecutor. Our job is to see that justice is done in every case, without fear or favor, without party or politics. It's unusual for a prosecutor like myself to testify about a criminal case. And as outlined further in my written remarks, there may be reasons why my testimony will therefore be limited in some respects. The Department of Justice has cleared me today to discuss matters related to the Roger Stone sentencing. Let me now turn to the Stone case. The first thing that every AUSA learns is that we treat every defendant equally and fairly. In the United States of America, we do not prosecute people based on politics, and we don't cut them a break based on politics either. But that wasn't what happened here. Roger Stone was treated differently because of politics. At the time of these events, February of 2020, I was a career assistant United States attorney, as I am proud to be now. I was not privy to discussions with political leadership at the Department of Justice. My understanding of what happened is based on two things: what I saw and what I heard. What I saw was that Roger Stone was being treated differently from every other defendant. He received breaks that are, in my experience, unheard of, and all the more so for a defendant in his circumstances, a defendant who lied to Congress, who remained unrepentant, and who made threats against a judge and a witness in his case. And what I heard repeatedly was that this leniency was happening because of Stone's relationship to the president, that the acting U.S. Attorney for the District of Columbia was receiving heavy pressure from the highest levels of the Department of Justice, and that his instructions to us were based on political considerations. And I was told that the acting U.S. Attorney was giving Stone a break because he was afraid of the President of the United States. I believe that was wrong, and together with my fellow line prosecutors, I immediately and repeatedly said so. Unfortunately, our objections were not heeded. First, we were pressured to reduce the initial sentencing guidelines calculation for Mr. Stone without any clear legal rationale for doing so. When we refused to go along We were instructed instead to disregard the guidelines entirely and to recommend an unspecified lower sentence for Mr. Stone. I was told that to the best of anyone's recollection, such a recommendation has never been made by the Fraud and Public Corruption section of the United States Attorney's Office. When we again refused, we were told that we could be fired if we didn't go along. I notified the office that I intended to withdraw from the case rather than file a memo that was the result of wrongful political pressure. And while all this was happening, I was repeatedly told the department's actions were not based on the law or the facts, but rather on political considerations, Mr. Stone's political relationships, and that the acting U.S. attorney was afraid of the president. Shortly after I informed the office of my intent to withdraw, office leadership changed its position and allowed us to file a sentencing memorandum properly calculating the guidelines and seeking a guideline sentence. We filed the memo and heard nothing further that evening. But at 2:48 a.m. that morning, the president tweeted that the sentencing memo was horrible and very unfair and cannot allow this miscarriage of justice. Later that day, we learned the department was going to issue a new sentencing memorandum, mischaracterizing the application of the sentencing guidelines and asking for an open-ended downward departure for Mr. Stone. We were not allowed to see the new proposed memo. We weren't even told who was writing it. At this point, I made the difficult choice to resign from the case and my assignment in the U.S. Attorney's Office in D.C. I resigned because following orders would have violated the oath I swore when I took my job. To be clear, my concern is not with the sentence Mr. Stone received. I'm not here to criticize the sentence or her reasoning. My concern is about process. The Department of Justice treated Roger Stone differently from everyone else, and I was told that the department cut Roger Stone a break because of his relationship to the president. I take no satisfaction in publicly criticizing the actions of the Department of Justice, where I have spent most of my legal career. I have always been, and I remain proud to be, an assistant United States attorney. It pains me to describe these events, but as Judge Jackson said in this case, truth still matters, and so I'm here today to tell you the truth. I would be pleased to answer your questions.
Our great senators. Hi, Chuck. He used to love me when I was a Democrat, you know.